Good evening to everybody. Welcome to the today class to the students of the Advanced Private International Law. And I posted something on the, yes, I will show you again because it disappeared. Yes, I posted something on the screen. Please read. Anyone can unmute and read what I posted on the screen. So it is nothing but, it is foreign judgment enforcement. That was the thing which I posted on the screen. So, enforcement, how a foreign judgment can be enforced, recognized and enforced, and that I posted on the screen. And let us see how it can be done. Okay, just a minute. Yeah. Then I found. Yeah. A foreign judgment, recognition, enforcement of the foreign judgment. Yeah, just a minute. Let me open this one. Yeah. So in the East Africa, this is about the East Africa, that's why I would like to deal it. And where are they? Yes, it is here. Paste. Recognition and enforcement of the foreign judgment in East Africa. That today we will deal this class. So now let us see. I can scroll down here. Which one is there to scroll down? Yeah, it is. I found it. Yes, can anyone unmute and read what I posted on the screen? Could you able to see it? Raymond Cosmos, could you able to see that what I posted on the screen?
Yes, sir.
Read.
Recognition and the enforcement of foreign judgments in East Africa.
Yes, it is written by Nislima Irene. Nislima Irene, yes. Go through.
International arbitral awards are fundamentally different from foreign judgments in terms of both recognition and the enforcement of former being a result of arbitration proceedings and the latter being a result of convention litigation in court.
Yes. International Arbitration Awards. See, we studied the International Arbitration Award in the Raymond, what is that? Raymond versus Tenesco. Raymond Dawn, not Das. Doyas, yes. Raymond Doyas versus Tenesco, that ICC arbitration award, we studied it. When the parties agreed to the arbitration, at that instance, no court will interfere in that matter until if there is a fraud happened over there, if there is a gross negligence is over there, at the time that the High Courts and Court of Appeal may interfere. So here the international arbitration awards are fundamental different from the foreign judgment. A little difference would be there, but when you see it, either the award is concerned or the judgment is concerned, when it is a matter deals with the money matters or commercial matters, the application is the same. Judgments in terms of the both recognition and enforcement of the foreign being a result of arbitration proceedings, and the later being the result of the conventional litigation in court. But only the difference for the arbitral award and the foreign judgment is arbitration award is made by a different charter or the treaty, and the foreign judgment by the different charter and the treaty. So, result of the conventional litigation in the court. As a conventional litigation, how you follow it, the same way that arbitration award also be followed. The same procedure would be followed, like the followed in the foreign judgment. There is no regional legal framework for the enforcement of the foreign judgment in East Africa. But in Tanzania, there is a act is there, and we studied it. And that act I clearly mentioned in my joint author article, which is published by the LST, Law Review. And I posted to each and everybody. So there is no regional legal framework for the enforcement of the foreign judgment in East Africa. The EAC treaty does not cover this, and in the absence of the legal regime and at the regional level, countries will follow the rules of enforcement of the foreign judgment in their jurisdiction under the domestic laws. So bilateral treaties or multilateral treaties would be there. At that instance, definitely foreign judgment will be followed. Or if any judgment is taken into consideration and as it is using in another country, at that instance, without losing the sovereignty of that country in the reciprocal manner, even that country used, adapted, and should have to, that country judgment also would be adapted and given the reference by the another country. For instance, A country judgment is there, and A country judgment, the B country as it is followed to give the justice to the party. At that instance, whenever the B country decision would be there, which is given by the competent court, and that judgment can also reciprocally followed by the A country because of the doctrine of comity. So majority of so here they say there is no regional framework would be there except the charter or the treaties, and with that they will give the respect to the foreign judgment of the other country. But the India is having, sorry, Tanzania is having an act with that 11 countries are there. How many? How many?
11 countries.
11 countries are there where it could be followed. Among the 11 countries, Kenya is not there and Uganda is not there as far my knowledge goes. So majority of the East African states, now the East African states are how many? How many East African states?
There are 6.
6 or 7. Even DRC also came. Okay. Even DRC also there, is it not? Actually 5 are there, but
Yes.
another one is added. Is it Rwanda is not added? When DRC is added, I believe the Rwanda should be added. Why confusion? Just we can make it out. Oh, it is. How many countries are there? We can make it out just now. East African community. I think it is just 7, if I not be mistaken. East African community states list. East African Community EAC is a regional intergovernmental organization of the 6, you are right, 6 states comprising Burundi, Kenya, Rwanda is there. But including the Rwanda, it's only where is the DRC? Even DRC also come into the picture. I think that is the old one, I believe. East African EAC. How many member states are there in the EAC? 7 partner states, because DRC is there. So I am right. Polesana Raymond Chow. Raymond. East African Community EAC is a regional intergovernmental organization of the 7 partner states, the Democratic Republic of the Congo, DRC. What is the name for the DRC earlier?
Democratic Republic of the Congo.
What is the name of the DRC earlier? Zamani. Earlier name. Like Tanzania, earlier name is Tanganyika. What is the DRC earlier name? Farmer name. Say Pasan. Say Pasan.
Pass on.
Zaire. 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 I think E is there or not, but Zaire. Zaire is there or not, but it is called Zaire. Now it is becoming a Democratic Republic of Congo, and there the official language is, what is the official language of the DRC? If you don't know, you say Masa.
Congolese and Lingala.
On passport, Lingala language is there, or Congo language is there on the passport? On the passport, official language is French. French language will be spoken over there. And a passport also written over there in French. And it is democratic only PSA, and democratic, that is, they made it like that. A French name is there on the passport. If you can see anybody's passport of the Congo, and you will find it. There is a French, it is written over there. So now, Republic of the Congo, Republic of the Burundi, Kenya, Rwanda, South Sudan, Uganda, and the United Republic of Tanzania. And headquarters is Arusha, Tanzania, that is. So now, why I have taken this aspect means, if there is a treaty would be there, at that instance only, the recognition would be there. And the 11 countries only there in the treaty, and where the Tanzania is one of them. So let us come to the point. Majority of the East African states have a domestic legislation on recognition and enforcement of the foreign judgment based on reciprocity. What is give respect and take respect? Reciprocity. That a country shall recognize and enforce a judgment of a court of another country if that other country affords equal recognition and the enforcement of judgment of that country. Just before I have given the example of A country decision, judgment will be followed as it is by the B country. At that instance, B country decision also be followed by A country. B country decision will also be followed by the A country. So in Uganda, there is a legislative enabling the enforcement of the Uganda for the judgment given in a foreign country, which accord a reciprocal treatment to judgment given in Uganda. The legislation also facilitates the enforcement in the foreign country of the judgment given in the Uganda. See, either Uganda or Kenya or Tanzania or Rwanda or South Sudan, if any judgment is given over there, if it is followed by another country, then naturally the same thing would be made by the other country also in the same manner. See, when you say annotation, there is a matatizo is there, problem is there. Okay. So how it can be, the law is embodied in the Foreign Judgment Reciprocal Act. In Tanzania also there is a act that is the same, Foreign Judgment Reciprocal Act is there. A judgment creditor may reinforce a foreign judgment in Uganda or Tanzania because of the act is there. In compliance with the prescribed procedure, a procedure would be there. First they have to give the notice to the High Court. Enforcement is preceded by the registration. A judgment creditor will register the foreign judgment in a court. He is to give the notice and register it. It must be a judgment or order of the superior court of the foreign country. It should not be given by the district court, or it should not be delivered by the resident magistrate court, but it should be delivered by the
High Court.
Either High Court, at the most Court of Appeal. Because after High Court also there is an appeal is there. Unless until the limitation period is over of the appeal, yes, High Court decision also. Because when the decision is given by the High Court, there is a limitation period would be there to make an appeal. Of course, Limitation Act clearly says either 1 month or 2 months or 3 months. Generally, the 3 months are there in general practice. But some cases only 1 month you have to file a case. It depends on the country to country. So the apex court, the superior court of the foreign country, and that judgment will be holds good, because after that there is no appeal. So given in the civil or criminal proceedings, but our is only civil proceedings. We don't consider the criminal proceedings. But in certain respect, they also consider the criminal proceedings for the payment of sum of money. Of course, check bounce case is a criminal offense. Check bounce case is a criminal offense. What is meant by check bounce case is a criminal offense? Tell me. Explain. Or say pass on.
Pass on, sir.
Check bounce case, bounce. Check, checks will be given to the bearer or account payee.
Bro,
Yes.
Kyo is asking you to let her in.
Oh, she's in the lobby. But I could not see the lobby. No one is there in the lobby. Oh, yes, she is there. She is there. Yes, she's in the lobby. Okay. Check bounce case means, suppose if you given a check to A, bearer check, and that is rejected by the bank because there is a deficiency of the amount. At that instance, it will be dishonored and say no sufficient amount in his account, hence it is dishonored. That is called a check bounce. If you give a check to somebody else without having the money in the bank, there is a criminal case would be there. I don't know whether Tanzania it is there or not. I'm sure there is a criminal case. And in India, we say Negotiable Instrument Act of Section 137. It will deal about that one, the criminal offense. So here, either the civil or the criminal proceedings for the payment of a sum of money in the respect of compensation or damages to an injured party. So apex court should have been given, and that country law would be very much beneficial to the plaintiff. I told you in my yesterday class also. If the Tanzanian law would be followed over there is a cap, means ceiling is there. Suppose if the other country law would be followed over there is no limit for the compensation. Even exemplary damages also avoided over there in certain cases. And that is the reason they will take the judgment of the law of the other country. So what if there is no reciprocity? Suppose there is no reciprocity, means I don't honor the judgment of India, means Tanzania. In the same manner, India also does not honor the judgment of the Tanzania. So if there is no reciprocity, what happens to a holder of a foreign judgment seeking to enforce it in Uganda or any country from the superior court of the country which does not afford reciprocal treatment to judgment given by the superior court, either Uganda or Tanzania or any other country? Does it mean that such a judgment cannot be registered and enforced when there is no reciprocity? Is it clear? Say yes. Say yes or no. I repeat, if there
Yes,
is
sir.
no reciprocity among the countries or between the countries, at that instance, no court will register such a judgment and honor such a judgment because there is no cooperation between the two countries. And that the judgment holder will be stranded. He will not do anything with their judgment. Just he will keep the judgment in his hand and keep quiet because there is no reciprocity between or among the countries. If there is a reciprocity, definitely that judgment could be used over there and honored over there, and recognition, enforcement of the judgment is there. And the courts in Uganda or in Tanzania have been faced with such a cases because I told you, there is no reciprocity between the Tanzania and Kenya, including the Uganda. So one of them is the case of the Christopher Sales. Of course, he has given one of the case of the Attorney General of the Uganda, where court had to decide whether a valid and unsatisfied judgment entered by the court in the USA was registrable and enforceable by the court of Uganda or Tanzania, because the judgment is of USA. So such a judgment could be honored over there or not, unless until there is a reciprocity between the one country, means Tanzania or the Uganda or the Kenya, with the USA, then it can be honored. If there is no reciprocity, the court will not register and honor such a judgment. In the absence of a reciprocal arrangements with the United States on mutual enforcement of the judgment entered in their respective jurisdiction. So if the absence of the reciprocal would be there, it cannot be holds good. If the presence of the reciprocal arrangement is there between or among the states, yes, foreign judgment can be honored. So court noted that the court noted that the issue on trial was not one of the reciprocity, because quite clearly there was no reciprocal arrangement between Uganda and the USA. I don't know whether there is a reciprocity there between the Tanzania and the USA. No, because it is not there in the 11 countries. Excuse me. The question that needed to be determined by the court was to what a judgment debtor standard. With a judgment from a country with no reciprocal arrangement with the Uganda, like in that case, is supposed to be to do with the judgment. What is such a judgment debt supposed to do to enforce, if at all? Can he enforce the judgment? Suppose if there is no reciprocity? Answer, no.
No.
Answer, no.
Says
Because there is no reciprocity between the countries or among the countries. So court applied the two theories in determining the matter. Of course, they are following it. The theory of the obligation and the theory of the comity. I told you, no comity, reciprocity. The obligation, yes, suppose if the natural justice would be there to obligation of a particular case, at that instance, with a natural justice, they can do so. The theory of obligation, which states that the judgment of a foreign court creates a debt and liability to pay, unlike the theory of the reciprocity, which states that the court of our country should recognize and enforce a judgment of another country if the courts of such a country recognize the judgment of the other country. Suppose if there is no recognition between the two states, and I'm sure that nothing can be going to happen. Nothing can be going to happen. The judgment merely restricted to the paper. So while applying the theory of the comity, court followed the position taken by the United States that when an action is brought in a court of the United States by a citizen of the foreign country against the US citizen to recover a sum of money adjudged by a foreign court and a competent jurisdiction of the cause and the parties, and upon the due allegation and proof, opportunity to defend against them and its proceedings are according to the course of the civilized jurisprudence and are stated in a clear and the formal record, the judgment will be recognized and enforced in the United States unless some special ground is shown in impeaching it, or if it is proved that it was effected and obtained by the fraud. If the judgment is obtained by the fraud or prejudice that the principle of international law, and by comity it is not entitled to full faith and credit. So now what it is saying exactly, it is like that. Suppose the two persons are USA citizens, and the one of the USA citizen has taken the debt in Tanzania, and he did not pay the debt with the interest. because the transaction is happening in Tanzania by the true citizens of the USA, and the breached one who got the victim, and he filed a case in the court of Tanzania. At that instance, Tanzania will given the judgment without bias in Tanzania. Can such a judgment will be taken into consideration by the USA? Because that fellow doesn't have the properties in Tanzania, but he is having the properties in USA. At that instance, yes, USA will take the decision of the Tanzania because the parties are both citizen of USA only. Are you following me? Are you following me?
Yes.
Both the,
Yes, sir.
is it a private international case? Is it a private international case? Hapana. In private international case, what should be needed? What should be needed? In private international case, what should be needed? One of the party should be another country. Repeat. Repeat. Anyone can unmute and repeat. One of the parties should be a foreign country. Suppose if I give the example like this, a Tanzanian and an American citizen, and they made a contract in Tanzania, and the American citizen has breached the contract. A forum shopping Tanzanian has filed a case in the Tanzania, Lex 4E, and the judgment is given by the Tanzania that he is supposed to pay this much compensation with the interest. Can such a judgment, because that fellow doesn't have the properties in USA citizen, doesn't have the properties in Tanzania, let me presume it, and he's having a lot of properties in USA. Can this judgment will be recognized and enforced in the USA? Yes. If you see the natural justice, you can say yes, even though there is no reciprocity in the two countries, because any country's citizen should not be suffered. That is the motto. Is it clear? Is it clear?
Yes, sir. It's clear.
So now, court agreed with the plaintiff's submission that the committee is concerned with the maintaining the amicable working relationship between the nations. Yes. If you come to my house, I offered you milk. If I go to your house, you are supposed to offer what? What? Milk. Because you enjoyed the milk in his house. At that time, you are not supposed to give the maji, water. Reciprocity should be maintained over there. And that is a very important factor. A relationship between the nations, a shorthand of good neighborliness, common courtesy, and a mutual respect between those who labor in the adjoining judicial vineyards where point of law is raised, if decided one way, would be decisive of litigation. So, when I am giving the respect to you, and you also give the respect to me, that is the way we can say that give respect and be
respected.
Take respect. If you give respect, people will will give you the respect. That means you take respect. Give respect and take respect. If you don't respect, people will not respect you. The courts also followed the earlier ruling. Of course, he has given one of the ruling there. The law of the nation that a state is bound to enforce within its territory, of course, because the law of the land will prevail over there. And the law of the land of the Tanzania cannot be applied in the jurisdiction of the India. The judgment of a foreign tribunal, and when matter comes to the money matters and commercial matters, yes, the jurisdiction will be extended to the other country. That is, several of the continental relations, including the France, don't enforce the judgment of other countries unless there are reciprocal treaties to the effect. But in England and in states which are governed by the common law, such judgments are enforced because they have the common understanding would be there, because both the countries are common law countries. And not by virtue of the treaty. It is not by virtue of the treaty because it's a common law country, nor by the virtue of any statute because it is a common law country, but upon a principle of, what are the principle they used? Number one, common law country. Number two, upon a principle well stated that where a court of the competent jurisdiction had adjudicated a certain sum to be due from one person to another, a legal obligation arises to pay that sum on which an action of debt to enforce the judgment made by may be maintained. Just before I have given an example, what is that? A Tanzanian citizen having a contract with a USA citizen in Tanzania, and the USA citizen made a breach of a contract. At the time, the forum shopping, the Lex Fori, the Tanzania has given the judgment against the USA citizen, and that judgment based on the obligation of the other country, because he doesn't have the properties in Tanzania, even though there is no reciprocity, even there is no statute, even there is no understanding, but still obligation would be there on the United States, America, to see that a Tanzanian citizen who undergone the breach of contract and where he suffered a loss, that would be paid with the interest, marketable interest there. And that judgment could be used as it is in the USA, and the judgment debtor would be there, and from his estate, the amount will be realized and paid to the Tanzanian citizen. So that is the same thing it is said here. What is that? The judgment creditor armed with such a judgment, armed with his having such a weapon, should be allowed to realize the fruits of his judgment, which is given by the Tanzania, which should be afforded to recognition by the court of other country like America, in the absence of what? Reciprocal arrangement. There is no reciprocal arrangement. Yes, because the obligation is there. The court went ahead to grant the prayer that the judgment is enforceable in USA. Awarded the interest, with the arrears, interest with the dates of the award till the payment is full, and cost of the suit, even the cost of the suit with the interest. Are you following me? Even though there is no reciprocity between the two countries, then what the theory will be applied over there? What the theory is applied over there? If you know it, you tell me. If you don't know it, you say pass on.
Principle of comity.
No, comity is not, I said no, there is no reciprocity. And there is no such a thing. It's the theory of obligation. Theory of obligation to make the judgment would be followed in the USA. Because the USA citizen, he doesn't have the property in Tanzania, but he made a breach of contract. With the interest, he should have to be paid by the USA court will honor the judgment of the Tanzania, even though there is no reciprocity, because It is a natural justice and an obligation on the part of the United States of America of the citizen who made a breach of a contract in Tanzania. Even though there is no reciprocity, committee is not there, doesn't matter, but obligation lies on him. A theory of obligation is there. How the obligation? You read in the quasi-contract. In the quasi-contract, there is no offer and acceptance. Are you following me? Are you following me? Quasi-contracts. QUASI, quasi-contract. There is the obligation on the part of the people to pay the amount. For instance, you know mowing, MOWING, mowing. You know it, tell me. MOWING.
Pass.
You know lawn, LAWN, lawn.
Pass on, Prof.
It is nothing but grass, the green grass lawn. And when the grass grows more, a machine would be there, mowing machine. It will cut the grown grass and make it level. That is called mowing machine. So, for instance, a mowing machine man thinking that you have given the order to mow his lawn and he is mowing the adjacent land. When he is mowing the adjacent land, the owner saw it and he kept quiet. And he did not say, who asked you to mow my lawn? But he kept quiet. In the evening, he asked, please give me the amount. Then the owner said, why I should have to give the amount? Did I make an order to you to mow my lawn? You only mowed the land. He goes to the court. The court says, it is the obligation on you. When he is mowing your land, you should have to stop him at that instance only. But you did not stop him and you allowed him to mow the land till the evening, means you have given the consent to pay the amount. The obligation lies on you to pay the amount, even though there is no specific offer and acceptance is there. That is called quasi-contract. Is it clear?
Yes, Prof.
Yes, sir.
You did not study the quasi-contract in the contract. It is also called equity principle is used in the contract. Equity principle. To my knowledge, because I didn't know here, but in India, we studied it from 64 or 66 to 72 sections of Indian Contract Act. Quasi-contract. And its heading is, it is a resemblance like a contract. The contract which is a resemblance like a contract. So that is the title which will be there. And even I wrote the book Law of Contract, the General Principle of Contract in Tanzania. I think in the South Library it may be there. You read, or any book you read, quasi-contract. So here, even though there is no such an offer and acceptance, but the obligation lies on. That means that is the equity principle would be there. He has to supposed to pay to that man, even though there is no offer and acceptance. So here, if there is no reciprocity between the two countries, but the obligation lies on the other country to give the justice to the party, and hence it will be implemented as it is, the judgment of the Tanzania in USA. These acts also provide the enforcement of the, say, Uganda or Tanzania, if any arrangement warrant for the arrest of the defendant in the civil cases, either before or after the judgment from the above countries, subject to the provisions of the plaintiff of security for cost. See, some of the cases, no, suppose if you did a murder and you went to the another country, and that country has given the asylum to you, protection to you. If there is the extradition treaty is there, and that country will hand over the criminal to you. If not, it will not do so. unless until there is a treaty between or among the countries. I don't know whether is there in India a person who is a Kingfisher owner and Ajay Malia, I think Vijay Malia, and he's a person, you type it, and he has several crores he make the scam of the IDBI bank, and now he is there in London. And he's not good. And the London government and the UK government will not allow him to go back because his properties are more in UK, and he's paying lot of what I say tax to the UK government. Are you following me? Vijay Malia, his name is. You type it in the Google search engine. Vijay, Vijay, Vijay Malia, Malya. He's a very big business tycoon, very big. And you know Kingfisher beer, it is very famous in India. Kingfisher is beer, like here Chewy Chewy. And then the Kingfisher planes are there. So he is having a lot of property. Now he is taking the asylum there in the UK, and he is enjoying the life over there. So now there is a lastly the Reciprocal Enforcement of the Judgment Act. Of course, Tanzania is having, which provides for the enforcement of either Uganda or Tanzania judgment made in the United Kingdom or and other Commonwealth countries and the Republic of Ireland. And there are 11 countries are there where the Tanzania is having the reciprocal understanding between the 11 countries, where Sri Lanka also comes over there, but other will not come. So what are the countries? And we discussed also this thing. Let me see what are the countries are there where, and okay, let me check this one. Okay, what are the countries? There are the 11 countries, but there is no Uganda and Kenya. See, I will type it, I will show you. What are the countries? What are the countries who are member in recognition and enforcement of foreign judgment? No, we should write Tanzania also. For judgments in Tanzania. In Tanzania, we have to write. In Tanzania. Then only it comes. Yes, it came over there. Countries that enjoy the reciprocity treatment under the Act are limited to 11. I told you 11. Kumina moja. Namely, Botswana, Lesotho, Mauritius, New South Wales, Zambia, Seychelles, Somalia, Zimbabwe, Swaziland, United Kingdom, and Sri Lanka. Reciprocity of foreign judgment by the Tanzania are only 11 countries. So here the title is given, Enforcement and Judgment in Tanzania. And please read this article. Of course, we discussed this, and it is only a repetition now. It is only a repetition now. Otherwise, we have discussed it. Enforcement of the foreign judgment in Tanzania, what in-house lawyers and the foreign lenders need to know. So please take the screenshot and you read the judgment and how the Tanzania is recognized in the reciprocity of the foreign judgment. And this is the thing, and it is very short. You can just read it, but you take the screenshot so that you could know. If you type that same thing, it will come. Still 5 minutes are there, and you take the screenshot now, because there is a HTTP URL also comes. HTTP URL universal. What is that? Universal URL. I think some full form is there. I don't remember now. So you take the screenshot of this one, and this is also very helpful to you regarding the enforcement of the foreign judgment and how Tanzania will do it. Is it clear? Now I would like to play a small video is here, and I want to see that this would be useful to you. I say stop sharing, then I will say share, then I will make it out. First I have to open it, then I will make it out. I say share, yes, and now you can hear it.
How to enforce a foreign judgment. A foreign judgment is a judgment entered into in any jurisdiction but your own. It can be a judgment entered into in a different state or even a different country. Generally, a state court only has power to address matters within its boundaries. However, there are several ways that a state court may be able to enforce a foreign judgment. Number 1. Money judgments from other states. The U.S. Constitution provides that judgments from one state should be given full faith and credit in other states. This means that a judgment entered into in one state should essentially have effect nationwide. However, for a state court to enforce a foreign judgment from another state, the home state will have to domesticate the judgment. The process of domestication entails the creditor filing the judgment in the home state, and then the judgment will be treated as if a court in that state made the judgment. After the filing, the judgment will then be served on the debtor, and the home state court can enforce the judgment. Number 2. Non-monetary judgments from other states. It can be much more complicated to enforce judgments from foreign jurisdictions that have to do with non-monetary concerns. In many cases, you may need to file an independent civil action in your home state and seek a new judgment. But while you may need to file a new lawsuit, you should know that the foreign state's ruling is usually given great deference so long as that state had proper jurisdiction over the matter and there is no indication of fraud. Number 3. Money judgments from foreign countries. The U.S. is not obligated to recognize any judgments rendered in a foreign country, just as foreign countries do not have to recognize a monetary judgment made in the U.S. However, some states do have laws that provide for recognition of foreign judgments. You will want to talk to an attorney in your jurisdiction to learn the laws in your state. If your state does recognize monetary judgments from other countries, the creditor typically will need to bring an action in the home state so that the state court can domesticate the order.
So you heard it how the judgment could be made and how it can be enforced. Is it? Say yes.
Yes, sir.
Yes. So the judgment, see, there is an obligation is there, non-monetary judgments are there, and the monetary judgments are there. How it can be made it over there?